Hello and a very warm welcome to you. This is the courthouse where we get to learn the law in plain, simple and entertaining language. And of course, we've been treating different issues that directly affect you and I as legal entities. Of course, you are a legal entity, I'm a legal entity. And this week on the show, we are going to be taking a look at the relationship between workers and their employers. Is there any relationship? Does the employer owe the worker any duty to actually ensure his safety? These are issues that will be coming up today. I am Itohan Olomu-Agbodo. We'll be right back after this break. Welcome back. If you just joined us, this is the courthouse, and this week on the show we are looking at workers' compensation, and of course we are going to look at the relationship between employers and employees. Do employers also require compensation? Of course, as usual, we are joined by a seasoned legal practitioner, and he is none other than Clement Echo. You're welcome to the courthouse, sir.
It's my pleasure. Thank you for having me.
Okay, so as usual, you're going to give us a background to what we should actually be expecting when we hear about workers and employers and compensation generally. Give us a background to that.
Thank you. By talking about compensation or workers and employers relationship, first and foremost, we cannot talk. I would like to say that we wouldn't be talking about compensation when it comes to worker and employer without first establishing the existence of an employment relationship, because it's not everybody that can go and hold an employer. In fact, before you even confer or recognize anyone as an employer, which means there would have been a subsisting relationship. So when we are talking about employer-employee, we're talking about a relationship that has come into being as a result of the need of either an organization to require the services of an individual, and the individual is also willing to provide his services to that organization or an entity or an individual, and be on the basis of back and forth bargaining and negotiation and interviews, both parties come to a consensus as to well spelled out plans, obligations, rights, duties and responsibility that will culminate into what we call a contract of service or of employment, whereby the employer engages the employee with a piece of paper to be acknowledged by the employee, and thereafter a relationship of employer and employee will commence. And by reason of whatever documentation they've signed, the employee knows that this is the basis upon which I have been engaged. These are the services I am going to be providing to my principal or to my master or my employer. While the employer also knows that there is also a concomitant responsibility, which apart from payment of maybe salary, depending on how they will agree, weekly, quarterly, monthly, yearly, or whatever. There are other compensations that will come with, or benefits that will come. There are other statutory responsibility and even at common law that the employer will be expected to do. For example, it will provide a safe, conducive environment for the employee to discharge his or her responsibilities. So these are also part of the things that will be taken into consideration. However skilled an employee will be, if you are going to put the employee in an environment that will jeopardize or frustrate his or her skills, the employee may not be able to discharge to his optimum capacity the skills that he or she had acquired. So it is part of the obligation of the employer to ensure that a safe environment is provided, a conducive environment is also provided, and that other in most instances, other employees that will be working with this particular employer are also competent and fit to work in that environment, because some of, when we talk about, later we'll be talking about injuries, some of the injuries or inconveniences that may come to an employee may be related to the expressing competence of another employee, or one thing or the other that may make an employee to be a misfit to work in that environment. And if such has happened, and there is evidence to show that complaints have been made to the management or to the employer as to some of these recurring misfits, behavior of a particular employer, and nothing has been done, if that will subsequently lead to maybe an unfortunate incident that will cause injury, that can be also basis upon which we'll talk about compensation. So talking about compensation or the relationship, that in summary is the basis upon which or how the employer and employee relationship comes in. There's an offer, there is an acceptance, and negotiations are coming in, spelled out terms of services, obligations as to what you're going to do, and also how that can be remunerated. Yes. When both parties are okay with it, then documentations are signed and letters of employment are given, acknowledgement of acceptance of same are given, and then you move on from there. So it is at that point that relationship have started. Then you are, as the employee, you are entitled to discharge your responsibility, and time to time you are reviewed based on that. So it is in the course of discharge of those responsibilities that we may begin to talk about incidents of compensation, where unfortunately maybe some injuries may have arisen. So that's the basis.
That's the basis of. Thank you for that background. Very, very insightful and in-depth, because we need to know, first of all, that there's a relationship. There must be a relationship between the worker and the employer for you to say you are suing for compensation, probably for injury, which occurred as a result of the discharge of your duties as an employee. So if there's an injury in the course of employment, I know that there's this jurisprudence as to what constitutes course of employment and all that. When can we say an injury occurs in the course of employment?
Well, in fact, under, this issue came up from the common law. And I quickly want to say that under common law, it is more hard to even prove some of these things. And it is as a result of some of the difficulties that have been found and identified under common law that made in modern times for the enabling acts to come up. Because under common law, like what you've just said, we may have circumstances where an employee may not be able to prove that he is actually entitled to compensation. For example, we have already established that based on the exchange of offer and acceptance, an employment had come into place, reflected or represented by documentation signed. Now, you have been assigned, let's use where we are. You've been assigned maybe to be the manager of where we are. And where we are is supposed to meet the international standard. But because you are an employee, and a skilled one at that, you come in and discover that the place needs some repairs or refurbishing, or some gadgets that we need to make it to be fit and proper, an environment for what it's meant to do. The question is, from your experience, what step did you take to call the attention of your employer into it? If you have taken the step and made recommendation, particularly maybe in writing, maybe 1, 2, twice, or 3 times, and they ignored it. One, you want to save your job, and maybe because you do not want to start going about looking for others, you may decide to say, okay, let me endure. Maybe pending when, they may even respond to you and say, okay, there may be a time we are working on it, we will do it. Then between the time that they say they are working on it and now, something unfortunately may happen while in the course of discharge of your responsibility in that place. The question you ask is, how do we know, maybe to the ordinary citizen who is walking on the road, how do we know what it means to be in the course of something to happen to an individual in the course of his employment. Is the fact that I am working or I am a staff of XYZ company, and then something happened to me somewhere, does it mean that it happened to me in the course of my employment? The fact that I've reported to work and then my work is in zone A, and then something happened to me when I attempted to visit zone B, does it mean that it happened to me in the course of my employment, even though it was within the same working hours, between maybe 8 and 5 o'clock? So those are some of the threatening questions that need to be answered.
Yes, and those are the questions we would be asking you that we need you to provide answers to. So we are going to be painting some scenarios. First of all, a police officer cleaning his gun. That was in a United Kingdom case in 1992.
Okay.
The officer was cleaning his gun in the house, not at the office, and the weapon discharged and he got injured. The court ruled in that situation that he was in the course of employment. We are also going to be showing you some other scenarios. Wow, you're welcome back. We're still having this very interesting discussion with Clement Echo, a legal practitioner based in Nigeria, and he'll be answering questions on what constitutes the course of employment. You saw those scenarios, you saw those instances where probably the courts would rule and in favor of the employee. These other scenarios, who is liable? Is the employer liable to provide compensation for injuries suffered in such circumstances?
Once an employee is able to establish a relationship of employment between him or her and the employer, and he goes ahead to establish that upon that employment, the activities that he or she was involved in, or he was involved in certain activities or discharge of activities in favor of the person who has engaged him, and that it was in the course of discharging those responsibilities that he incurred or an incident happened. And that incident that happened, are you following my theory?
Yes.
And that incident that happened led to the sustenance of an injury by him or her. And that injury had caused permanent, temporal, partial pain or disability or whatever, beyond the normal little injury. When we are talking about injury here, we are not talking about because you got a little slight cut,
yes,
and then you went when they're supposed to use the first aid of your dispensary to take care of it, and then you think you can come back and no. That's not the kind of injury that the law recognizes that warrants compensation. We are looking at injury that will lead to either permanent, partial, temporal disability, that would deny you, that has a capacity to deny the employer or the victim of subsequent means of earning.
Earnings, okay. So you probably stop earning because of that.
Yes, as a result of that, or even your capacity to earn falls down or reduces. So those are what the law. So as I was saying, so now you're engaged, you are involved in the discharge of the responsibility, and in the course of that, an incident happened, and that incident led to your sustenance of injury. And then that this injury or this incident ought not to have happened if my employer had taken or complied with the law or to do what he needed to have done to make the environment or the place of work safe. either by way of putting certain things in place, or if the injury or the incident that occurred was orchestrated by an other fellow employee, if they are taking steps to have either arrested the attitude of that employee by way of disciplinary or discharge of that. So you must bring about all of this to show that not only were you injured, but that you were injured as an employee who was, at the time the incident that led to the injury, was discharging his responsibility to his employer. And that it was flowing from that incident that happened that you got injured. To this extent, you will be entitled to compensation. Now, one of the incidents that we just watched with respect to the police officer, as the court has heard, when you talk about a police officer cleaning his gun at home, you may be wondering what is the relationship between the home and his office. The question is, before you even come to that, ask yourself, by reason of the nature and special or peculiar circumstances of his duties.
What happened in that case, they also established the fact that there was no provision for a place to keep the guns at the station. So he was actually required to take the gun home. So that was tested during the trial, and that made him...
Because if he had kept the gun in the office, either maybe by asking a colleague of his to keep it for him, and then tomorrow something happened to it, he will be held solely responsible.
Yes.
To say it behoves on you to take the gun. Even in Nigeria, for example, you remember one of the major threats to our forcemen is that on no account should you allow the arm that was assigned to you to be snatched away from you. That is immediate dismissal. You must account for it, and that is why they can stake their life to it. So until there is a provision for that, you cannot release your gun. And when you're releasing it, you sign for it. So if there is no place, you are entitled to go with it and prepare yourself for it. So you could see what happens. So that is it. Going forward, you can also talk about other issues where an employee attended a meeting with maybe his superior, and in the course of it, something happened. The scenario, the mere the declaration of the scenario had revealed that it was in the course of employment. Even the one who said, okay, I was called upon that, or I heard from a colleague that they've started paying, I need to come and pick up my pay check. In the course of going for it, it is still in the course of your employment. Otherwise, if the organization had thought it necessary that you do not need a paycheck to be received, all that they needed to do is to get your account details and credit this money into your account. If you choose to move from one jurisdiction to another to go and use your funds, you can go and do so. So that is it. But that would be different. And this is for the interest of our viewers. That would be different from the person who, yes, you've reported at work, maybe by 8 o'clock. And then, about 12 o'clock, under the guise that you're going for break, even break, going for your break within the statutory period, some organizations, they say 11 to 12 or 12 to 1. Going for break is also within the course of your employment. So should anything happen to you within that time, it will also be considered that it has happened to you within the course of your employment. And what we are saying about compensation here or injuries here is the injury can happen to the employee. The employee can also cause injury. You understand? So there is what we call vicarious liability that can also come to employer. Not because the employer has caused it, but because this agent of yours, this employee, stands in the position of an agent. So whatever the person does within these confines, he can be attributed or attached to you. So that if you're going to file a suit or a claim, you will not only put the name of the employee, you will add the name of his employer. Because for purposes of being able to assess whatever award or claim that can be given to you. But like I said, now, if you're under the guise that you're going for break, we found out that your break, some organizations have designated an area for you to go for your break. Or they made even canteens for you to go for your break. Then we found out that in your break, you're working on the mainland. And then we found you in Ekpe about that same time. or some minutes after that, and something happened. And revelation or discovery, we later found out that this thing happened kilometers far away
from your office
of
environment.
your environment, which is not possible. If you were on a special assignment by your employer, and it's a different thing because you will establish why you found yourself in that location. Sometimes you have this in cases involving drivers. You are asked to move from point A to point B, either to make a delivery or to carry out an assignment with a vehicle, the company's vehicle. And then from point A to point B, we know the kilometers, we know the time, we can decipher what it will take. And then suddenly, we found out that something, or you reported that an injury has been sustained, either on you or on against another person elsewhere, far away. The question is, how did you arrive at that place? The question now comes, and the contention. Can we say that in the location where this place, the incident took place that led to the injury, even though it is established that this person is carrying, he has a letter of employment, he has the ID card of this organization, can we truly say that the person or the incident that led to this injury happened in the course of the employment of the person? Or can we say that the person was on the frolic of his own, so that he cannot either claim from his employer for whatever injury he has incurred, or that the person, if he had maybe injured a third party, that third party may not successfully attach upon establishing of the liability, he will not successfully attach it against his employer, but against the person who caused the, because, generally a third party will not want to go because the person may not have the means to pay. So, and that's the reason why you will want to go after his principal. So that's the scenario under which you will consider the cause of employment. You must be under employment, and you must be carrying out the responsibilities, and you must be within the specified area that has been already stated to be where you ought to be. And the things that you're doing must be directly connected to your employment at the time that the incident happens. Otherwise, you may not be able to confirm or prove that whatever happened to you that led to the injury was in the course of your employment.
Very, very interesting. Of course, we've been learning from Clement Echo. He's been giving us scenarios that the worker, the employer or employee can actually claim compensation from the employer. Scenarios like injuries occurring in the course of your employment, and you must be able to establish that that injury occurred in the course of your employment, meaning you must be doing something related to your employment, related to the contract for which you were brought into the organization. The injury must have occurred within the confines of your office or in relation with whatever activities you ought to be legally performing at that time. You cannot be on a frolic of your own and expect to be compensated for an injury. And like he said, injuries are injuries that affect the ability of that worker to be able to gain wages, or injuries that will probably reduce his earning power. These are issues that we treated this week on the courthouse. And of course, this issue cannot be finished in one episode. So we'll be looking at the other aspects of it. We'll be looking at remedies. What type of remedies would accrue to an employee that can successfully prove that this injury occurred in the course of employment, and other aspects of the workman's compensation. And we have another segment, and that's the bar book.
All right.
I was just trying to create a scenario where you'll be relaxing and thinking, but let me quickly, I know the one that readily comes to mind when you're talking about workers and frolic of your own is Recip Salopito. So I'm going to stick with that so that I'll leave my learned friend to give us his own Latin marks.
Yes, also in relation to that, we have what we call under common law, volunteer non-fit injuria. Okay. A volunteer or someone who has volunteered his services, taking into consideration the risks that may be involved in the course of discharging those services, cannot later be held to complain of any injury. That's the summary of volunteer non-fit injuria. You cannot, as a volunteer, complain of injury.
Okay. quite interesting. My res salupitur means the facts speak for themselves. Of course, you get to find out more Latin maxims and their meanings in our Bar Book segments. You're welcome back, but at the same time, we have to go now. It's been a very interesting discussion with Clement Echo. At this time, I want to say thank you so much, sir, for being with us on the Courthouse this week.
It's a pleasure.
And
Thank you
of course,
for having me too.
we'd like you to conclude the other aspects of liabilities and remedies for injuries in the subsequent episode.
Anytime.
Okay. So you get to find out more information on our website on www.loverplus.tv. You can also send comments to info@loverplus.org, and you can send questions to the number showing on your screen now. I am Olomu-Agbodo. Don't just get mad. Go get a lawyer. Bye for now.